Of that kind of stuff.
You go to the open house thing?
Thank you. Sure.
It's definitely not centrally located to some degree.
Stress-free zone. We'll get there.
Doing great.
How y'all doing?
The best. How are you?
All right. 5 more minutes and we'll get this show started. We got a quorum, right?
Doing good. Keep everything on track and keep my head screwed on. Like the norm.
My phone's off. I know if I don't, they'll start ringing. You heard from Reed?
He said he may or may not come because he's been sick.
Oh, wow. Oh, wow. Okay,
But
yeah.
I mean, I had 5
Oh,
people.
yeah. If he's sick, he don't need to come. Don't come. Don't come.
Everyone's sick right now.
I know. Need to stay home if he's sick.
Young kids, 8.
It should be. Chairman Walker's here.
I'll say, no, we're waiting patiently. That's it. I've been getting beaten on a regular basis, and then he beats me. So I try not to, but I have to be. But hopefully it's coming to you soon. I hope. I can hear it, but when I get that letter, I'm running there to go, here, they said it's good. 4 years for me. I know Andrew is longer than I have on that. 4 years. Yeah, Sean, he got to leave.
All right. Good morning, everybody. Happy New Year. Hope everybody had good Christmas and holidays. We'll get this show on the road. It's the meeting of the Escambia County Planning Board for January the 7th, 2025 is hereby called to order with, what do we got? 6 members present. We have a quorum. Please remember to turn your cell phones off or put them on silent while we're in the meeting. If you could, please stand with me for the Pledge of Allegiance. Pledge allegiance. we have a proof of publication?
Yes, sir.
Did the publication meet all legal requirements?
Yes, sir.
I'll now entertain a motion to waive the reading of the legal advertisement.
So moved.
Got a motion?
Second.
Got a second. All those in favor, please signify by raising your right hand. All those opposed, motion carries. The rezoning meeting minutes from the previous meeting dated December the 3rd have been provided to the board members. Are there any additions, deletions, or corrections? If not, I'll entertain a motion to approve.
Motion.
We
Nope.
got a
Second.
motion, we got a second. All those in favor, please signify by raising your right hand. All those opposed, motion carries. All right, the rezoning hearing package for January the 7th, 2025 with findings of fact has been provided to the board members. I'll entertain a motion to accept the rezoning hearing package with findings of fact and legal advertisement into the evidence. Do we have a motion?
Motion to approve.
Second.
Second.
All those in favor, please signify by raising your right hand. All those opposed, okay, motion carries. Will the court reporter please swear in members of staff?
Please raise your right hand. Do you solemnly swear or affirm testify about the case of the truth, the whole truth, and nothing but the truth? So help you God, and so you do affirm.
All right. The board has previously qualified staff to offer expert testimony in the area of land use and planning. Does anyone have any questions regarding their qualifications and abilities to offer expert testimony? All right, seeing none. At this hearing, the planning board is acting under its authority to hear and make recommendations to the Board of County Commissioners, the BCC, on rezoning applications. These hearings are quasi-judicial in nature, and these hearings are like evidentiary hearings in a court of law, however less formal. All testimony will be given under oath, and anyone testifying before the planning board may be subject to cross-examination. All documents and exhibits that the planning board considers will be entered into evidence and made part of the record. Opinion testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. Before making a decision, the planning board will consider the relevant testimony, the exhibits entered into evidence, and the law. Each individual who wishes to address the planning board must complete a speaker request form and submit to the planning board clerk. These forms are on the back of the table, or on the table in the back of the room, and you will not be allowed to speak until we have received a completed form. Please note that only those individuals who are present and give testimony on the record at this hearing today will be allowed to speak at the subsequent hearing before the Board of County Commissioners, the BCC. At that time, no new evidence can be presented before the Board of County Commissioners. Therefore, all testimony and evidence must be presented here today. The planning board will provide a recommendation for each rezoning request to the BCC, which will review testimony, documents, and exhibits, consider the closing arguments, and make a final decision. All decisions by the BCC are final. Anyone who wishes to seek judicial review of the decision of the BCC must do so in a court of competent jurisdiction within 30 days of the date the BCC approves or rejects the recommended order of the planning board. All written or oral communications outside of this hearing with members of the planning board regarding matters under consideration today are considered ex parte communication. These communications are presumed prejudicial under Florida law and must be disclosed as provided in BCC Resolution Number 96-13. As each case is heard, I will ask that any board member who has been involved in ex parte communication to please identify themselves and describe the communication. As required by Section 2-7.2 of the Escambia County Land Development Code, the Planning Board's recommendation to the BCC shall include consideration of the following approval conditions. The applicant has the burden of presenting competent, substantial evidence to the reviewing board establishing that the requested zoning district would contribute to or result in a logical and orderly development pattern. The appropriate surrounding area within which uses and conditions must be considered may vary with those uses and conditions and is not necessarily the same area that is required for mailed notification. A logical and orderly pattern shall require demonstration of each of the following conditions. A, consistent with the comprehensive plan, the proposed zoning is consistent with the future land use FLU category as prescribed in LDC Chapter 3, and with all other goals, objectives, and policies of the comprehensive plan. If the rezoning is required to properly enact a proposed FLU amendment transmitted for state agency review, The proposed zoning is consistent with the proposed flu and conditional to its adoption. Criterion B, consistent with zoning district provisions. The proposed zoning is consistent with the purpose and intent with any other zoning establishment provisions prescribed by the proposed district in Chapter 3. C, compatible with surroundings. All of the permitted uses of the proposed zoning, not just those anticipated by the rezoning applicant, are compatible as defined in Chapter 6 with these surrounding uses. The uses of any surrounding undeveloped land shall be considered the permitted uses of the district. Compatibility is not considered with potential conditional uses or with any nonconforming or unapproved uses. In establishing the compatibility of a residential use, there is no additional burden to demonstrate the compatibility of specific residents or activities protected by fair housing law. D, appropriate if spot zoning. Where the proposed zoning would establish or enforce a condition of spot zoning as defined in Chapter 6, the isolated district would nevertheless be transitional in character between the adjoining districts, or the differences with those districts would be minor or sufficiently limited. The extent of these mitigating characteristics or conditions demonstrates an appropriate site-specific balancing of interest between the isolated districts and adjoining lands. E, appropriate with changed or changing conditions. If the land uses or development conditions within the area surrounding the property of the rezoning have changed, the changes are to such a degree and character that it is in the public interest to allow new uses, densities, or intensities in the area through rezoning, and the permitted uses of the proposed district are appropriate and not premature for the area or likely to create or contribute to sprawl. At the beginning of each case, as long as there's no objections from the applicant, we will allow staff to briefly present location and zoning maps and photos of the property. Next, we will hear from the applicant and any witnesses they may have. Then we will hear from staff and any witnesses they may wish to call. And then finally, we'll hear testimony from members of the public who have filled out a speaker request form. Today, we have one case to be heard. The rezoning application for consideration is case number Z-2025-01, which requests rezoning of 5200 block of North Blue Angel Parkway and 5600 block North Blue Angel Parkway from medium density residential MDR district 10 dwelling units per acre to HDMU high density mixed use district 25 dwelling units per acre as requested by Alara Mills Gutcher, agent for Lonnie Teston, owner. Members of the board, have there been any ex parte communication between you and the applicant, of the applicant's agents, attorneys, or witnesses with any planning board members or anyone from the general public prior to this hearing? Have you visited the subject property? And please also disclose if you are a relative or business associate of the applicant or the applicant's agent.
No to all.
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 All right, staff, was notice of the hearing sent to all interested parties?
Yes, sir.
Was notice of the hearing posted on the subject property?
Yes, sir.
And we've got, are we good with, is the applicant okay with staff presenting the photos? Okay. All right, staff, let you go ahead and present the maps and photos for the case today.
Okay. Good morning. I'm Allison Lindsay, Urban Planner Development Services. So this is the location map showing the parcel outlined on Blue Angel Parkway. This is the 500-foot radius map zoning showing the medium density residential zoning currently. This is the future land use map showing the mixed use suburban. And this is the location map showing the property site. This is the public hearing sign that we posted on site. And this is looking into the subject property. This is looking north along Blue Angel Parkway. This is looking east across Blue Angel from the subject property. Looking northeast across Blue Angel Parkway. And this is another public hearing sign that was posted a little further down because it was the two parcels. Looking south along Blue Angel Parkway from the subject property. And this is just another view into the subject parcel. Same one. Another view north along, looking north along Blue Angel Parkway. And that's the maps and photography.
All right, thank you. At this time, could we have the applicant or the representative to please come forward and swear in any witnesses that you may have, or be sworn in yourself? I guess.
Are you an attorney?
I am not.
Okay. Raise your hand. Do you solemnly swear or affirm the testimony about to give in this case is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. And then if you could just state your full name and address for the record.
Yes, my name is Alara Mills Gutcher. I'm a certified land use planner, and I'm in Lynn Haven, Florida.
Okay. And then
I am-
just a couple questions, and then I'll let you get going. I'm sorry. Just and then, did you receive a copy of the rezoning hearing package with the findings of fact from the county?
I did.
Okay. And then, do you understand that you have the burden of providing by substantial competent evidence that the proposed rezoning is consistent with the comprehensive plan, furthers the goals, objectives, and policies of the comprehensive plan, and is not in conflict with any portion of the county's land development code?
I'm aware, yes.
Okay. Good to go.
So I have been admitted as an expert witness to Escambia County in the past, for the record.
Board, if we would like to consider Ms. Mills Gutcher a expert witness today, I think that would be appropriate timing for us to have a conversation on that and see if that's something we want to do.
Yeah, I'd like to go ahead and move that we do so, but if you wouldn't mind, maybe sharing with the board, I looked at the website and I kind of did a little dive into it, but if you'd share some of your credentials, and I think we can certainly
Certainly.
get that in there.
Yes, so I have been in practice in Northwest Florida for about 25 years, regionally from Escambia County to Jefferson County, and I have worked on some projects in Central Florida. I have a master's degree in regional and city planning, and I have been admitted as an expert to DOA and to Circuit Court and to various county commissions throughout the region and city councils and Board of Adjustments. In fact, your Board of Adjustment here in Escambia County.
Yeah. And I'll say, I think you were on a case when I was on the VOA that we accepted you as an expert witness at that time. So
Mr. Speaker, I'd move that we accept her as an expert witness.
I've got a motion. Do we have a second?
Second.
Are there any questions? Further questions? All right. All those in favor, please signify by raising your right hand. All those opposed? All right. Thank you.
Thank you. As you are aware, this is a rezoning request and we are not changing the future land use map. I think we all agree that the request is consistent with the future land use category. Your staff has noted so in their report, so we'd just like to know that we are compatible, consistent with your future land use map in this request. I would like to give a little history. We actually submitted this application on November 20th for a request to go to the commercial designation, knowing that with the HDMU category, we are still going to have to go before the Board of Adjustment for a conditional use permit because the store size that is anticipated to be developed is greater than 6,000 square feet. And the restriction of the HDMU is that you have a sized store that is 6,000 square feet or less. So the application was actually submitted as a commercial request. And staff came back and asked us to revise that application, which is really highly unusual for staff to ask an applicant to amend an application, to go to the HMDU because it was more palatable for the request. So we did that. We resubmitted the application on December 2nd at the request of the county. I amended all of the application analysis to coincide with the HDMU category as a lesser category, knowing now that we will have to go back and come for a conditional use to the Board of Adjustment if this is accepted by the County Commission. So you have in your packet my analysis for the rezoning, which includes a compatibility analysis to show that we are compatible with the surrounding uses. And by Florida statute, the definition of compatibility is one that, excuse me, where we won't be contrary or cause a condition that will cause unnecessary hardship or use of property surrounding the area. As you're aware, this is over 6 acres. This is about 6.6 acres. And another point to mention is when we applied for the commercial category originally, we only asked to change the 2.5 acres that front the road. However, because there's 2 parcels, we were told that that's not something that Escambia County would be willing to entertain because they don't do split zoning on parcels, which is understandable. A lot of local governments won't do that. We were willing to subdivide that and reconfigure that, but the timing was such that we need to go ahead and proceed. The applicant does not plan to develop those other 4-ish acres in the back. They actually discussed even donating that to the county for some sort of park or some sort of use. We were told that the county isn't looking for extra property right now for those kind of uses. So here we are today applying for the amendment for both parcels for the 6.6 acres to the HDMU. Just rest assured that the only portion of the parcel that will be developed is the 2.5 acres that front the road that are adjacent to an existing commercial use, which is a quick food store, convenience store. So as we mentioned, the request is consistent with the future land use map. There is no inconsistency with the comprehensive plan. I did that evaluation. This is considered infill development because there is development surrounding it. It's not leapfrog development. It's not sprawl. It's in an area that's already developed. And so it's a vacant property, underutilized, that will be used as a Dollar General store, a Dollar General market. So it will have grocery to it. It's not just the convenience portion of it. Your staff has indicated also that that it's not consistent with the land development code because we talk about compatibility and we talk about the HDR and the HDMU and the commercially zoned properties, and that they are there's nothing next to it similar. Well, I submit to you there is something next to it similar. It's that food store, that food mart that's next door. And as your HDMU requires the intermixing of uses that are customary, if you're requiring that to be part of your zoning category, but the area in the vicinity is mostly residential. I think there's a house of worship in the area and then this commercial use. How does one start the intermixing if we can't take that first step? If we have an area that's suitable for this type of development, I submit that we should allow it with the appropriate buffers, probably in excess setbacks because of the size of the property, to allow for the compatibility and the consistency of the site with the surrounding uses. You know, today, if somebody came in, they could develop the whole entire 6.6 acres. There would be something abutting all of the sides. So that might not be as compatible as what we could do with the excess buffers and setbacks. And again, this isn't a high-rise building. It's a 22-foot store. So, and we also have reviewed your engineering specialist who prepared a memo that said there had no concerns regarding the proposed development. So we would submit to you that this is consistent with your land development regulations. This is something that is much needed in the neighborhood. These stores do not locate unless they've done a full analysis of the need and what could and couldn't happen here. And so we would submit that you find this consistent with your land development regulations and your comprehensive plan, as staff has indicated, and we request approval of the site, of the request.
All right. Thank you. Does any of the board members have questions at this time for the applicant?
I will say the development company is here, and I think they want to say a few words about the proposal also.
Okay. We'll go ahead and we'll take them. And we've got Josh Huffstetler, Jennifer Bell, Gary Watson, and Tyler Gray. Bill, are we all speaking or just?
I may be able to speak on their behalf.
Okay.
And then a lot of them are professionals that work for us that could answer some questions.
I gotcha. And Josh, if I could have you go ahead and get sworn in.
Raise your right hand. Do you solemnly swear or affirm the testimony about to give in this case with the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do. All right, so my name is Josh Huffstetler. I reside at 160, my business is at 165 Big Star Drive in Thomasville, Georgia. I'm the applicant, the potential developer of this property. I'm president of Terramore Development. Of course, we've been here. I started 18 plus years ago, and I've had a lot of success around this area. Pensacola was the first Dollar General location I built, and since then we've opened over 500 locations. I wanted to just kind of give you a brief rundown, and I won't take up a lot of time. I'm not a big talker or anything, but from our perspective in selecting this location and some of the things that we've done to try to adapt it to the community. Because at the end of the day, you know, in all the stores that we've opened, I'm a firm believer that it's important for us to partner with the communities. I mean, gosh, you guys know more than anything that we can fill a room with those in opposition really quick. There's a lot of stores. It's not always the most fun job, but at the end of the day, I want to do it better than most. And so in this scenario, you know, if we attempt to find a location that Dollar General wants to store, we always look for something that's already zoned appropriately. And unfortunately, in this scenario, the property just wasn't available, zoned. And so we looked at the site, and obviously not wanting to put a square peg in a round hole, we obviously targeted this one. It was available, and it was next to a convenience store. As Alara pointed out, the convenience store is unfortunately not zoned appropriately for its use, but at the end of the day, it is a convenience store, and so we just thought that, you know, the match suited the area, so that it wouldn't be considered spot zoning. And one thing that I do like to do whenever I can stretch the dollar is go into a situation and try to address our developments to suit the community as much as possible. So as Alara pointed out, in this case, we have an excess amount of property that we really do not need. And so, you know, offers were made to deed it to the county. At the end of the day, you know, I don't care what happens to it. I am a developer, so I like to see property utilized. You know, if right now our consideration for it is just to leave it green space forever. And I know this is quasi-judicial. You know, I believe we can place conditions on it, things like that, but I don't mind conditioning it to a deed restriction that leaves it green space forever. But the layout of our site in relation to the customers that are nearest our development is such that they would never see the development. And I understand because, again, I've built over 500 of these, and sometimes we have 500 people show up in opposition. Sometimes we only have a handful. You know, I want to sleep at night, and so going into this one, a few of the considerations that we've taken, I think the best one is the buffer. We've got 4 acres of green space so that any of the surrounding residents would never see our project. We went ahead and dressed up the store so it's not your standard Dollar General that's, you know, got the split face block and then the rest of it's metal. In this case, because we have such a large buffer, the only side that is metal is the very back, but nobody's going to see that side of the store because of all the green space. And so the upgrades include your split face block around the bottom, like 3.5 feet. And then from that all the way to the eave is going to be a hardy lap siding, which, you know, in my opinion is a good look, especially for surrounding residential uses. Importantly for this project is that it's not your standard Dollar General. Again, I've built over 500 stores. 98% of those stores are your standard Dollar General that's going to have the yellow signage and all of that. This is a Dollar General mini market is what they consider it. And so it's more of a grocery store. It's geared towards grocery. The entire fixture layout has shifted around so that the second you walk in the store, they've moved all the coolers and the produce, and you've got meat selections, and it's all right there in your face. And I would say that probably 70% of the store is devoted to grocery in these mini markets. The signage is actually green with a little bit of yellow Dollar General. And so, you know, what they're doing as a company is diversifying and finding a little niche where they can do these small grocery locations where it makes sense, where there's not, you know, a big anchor grocer right around the corner. And so I know this isn't land use specific, but important topics to note when we're, you know, considering rezoning a property and its impacts that it could have on the surrounding community and residents. And trying to think any other topics I may need to bring up. In regards, you know, to the property itself, so far in terms of opposition, we may find some today. I'm not sure. There's others that have raised their hand to speak. I'm an open book, and I love having neighborhood meetings, meeting with anyone that's willing to try to adapt our project to earn their commitment to be a good customer for our locations. And so I would just want to offer up to anyone that's here to please reach out to me after this meeting, and I would love to have that conversation. I don't have the easiest job in the world. I build a lot of Dollar Generals. Again, I get a lot of opposition to those projects. At the end of the day, I don't think there's a tremendous amount of opposition to this one, and I love that situation. But if there is anyone that wants to reach out, I would certainly be more than willing to entertain any thoughts they have on our project, as long as it's, just you've got to stop, you've got to kill this thing, because I do have a job at the end of the day, and it's to see this through, and hopefully we can do that.
Thank you.
Any questions?
Any questions from the board for the applicant or their representative? Not at this time? All right, we might get y'all back up here, but.
All right.
All
Thank
right,
you.
thank you. Staff, if we could go ahead and have your presentation at this time.
Before we get started, I want to be clear with the process going forward. And the attorney can chime in, that with the rezonings, and I know all y'all are agreeing, we're not focusing on just this case, on this specific use. We have to look at all of the potential uses as well. This is, and no disrespect to the Dollar General, we work together well. But however, rezoning is a different spectrum. So I want to make sure that we focus on the rezoning, not the BOA. If it's approved, the BOA can get into the specifics. But this is the rezone in which Dollar General may not decide to go somewhere else. So if it is rezoned, all of the potential uses can definitely have an impact on the area. So I want to state that for the record going forward, which I know all of y'all know, but we just want to be clear going forward.
Thank you.
Okay,
Yep.
board. Okay, so this is the rezoning at 5200 and 5600 Blue Angel Parkway, requesting MDR to HDMU. So on the, consistent with the comprehensive plan, in the Escambia County Comprehensive Plan and its implementing document, the Land Development Code, the county must consider the issues of compatibility of adjacent uses in determining the suitability of development projects. The HDMU allows in an allowed zoning category for uses of density within the mixed-use suburban. Incompatible development is defined as development that's proposed to be constructed next to existing development, wherein the proximity of the two kinds of development would either diminish the usefulness of the other or would be detrimental to existing operations, which can arise from either land use or structure size and design. The intensity of the proposed rezoning request is incompatible with the low-impact, low-intensity residential development in the area. Infill is determined as development of new housing or other land uses on vacant or underutilized land in existing development areas, which focuses on the reuse and reposition of obsolete or underutilized buildings and sites. The property does not meet the definition of infill development, and the staff cannot support the assertion that this is infill development because of the commercial uses that are allowed by the HDMU. Staff determined that the request to HDMU is not consistent with the comprehensive plan. So criteria B, consistent with the zoning provisions. The proposed amendment is not consistent with the intent and purpose of the Land Development Code. So the residential uses in the MDR are limited to single-family development, whereas the HDMU is a mix of high-density residential and compatible non-residential uses, and where the intermixing of the uses have been custom and some redevelopment is probable. HDMU district is appropriate to provide transition between areas zoned or used for medium or high-density residential and areas zoned or used for commercial. But still, there are no HDR, HDMU, or commercial zone properties adjacent to the subject parcel. The property does not meet the location criteria as stated in the HDMU zoning district. Blue Angel Parkway is a state road, and the FDOT will do the review and have any, and comments for any access or traffic issues. Criteria C, compatible with the surrounding uses. So compatibility is not considered with any non-conforming or unapproved uses. So the request to rezone to HDMU is not compatible with the surrounding residential uses in the area. There are no other commercial uses adjacent to the subject parcel, with the exception of the legal non-conforming use of the convenience store, which has been in operation for the past decade or more. The bulk of commercial businesses are located at the major intersections to the north, which would be Softly Field, and to the south, Lillian Highway. HDMU zonings will allow high-density residential development as well as a mix of neighborhood retail sales and services. The applicant stated that out of the 6.5 acres, the front 2.5 acres would be developed, leaving the large buffer area that abuts the residential subdivision undeveloped. The additional buffering above the county requirements will provide greater separation between residential and commercial development. Additionally, buffering will minimize or eliminate adverse impacts on any adjoining residential uses. But never mind. So criteria D, spot zoning. The request to HDMU would be considered spot zoning as there are no adjacent parcels that are HDMU, therefore extending the privileges that are not generally granted to other properties similar in the location of the area. Criteria E, approved with change or change conditions. There is growth happening along Blue Angel to the south. However, the land uses or development conditions surrounding the subject parcel have not changed. The request to rezone would allow more intense development along Blue Angel, and the permitted uses of the HDMU may not be suitable to coexist with the residential uses in the area. And that's staff's findings.
Are there any questions from the board for staff?
Real quick, Mr. Chair. Horace, here we are again. Feel like this is reminiscent of another issue we had where the only difference was that the zoning was commercial. It was much closer to residential. In fact, on all four sides, single-family homes. Would you agree that this is also, we're here in a bit of a quandary because of the fact that we didn't label these until '95, and now here we are in Blue Angel Parkway with an MDR in a situation that could be argued either way with the non-conforming use directly next, it's right next door. And my question to you is this, is before we failed, and if I recall, the attorney was fairly smug in saying, I want to get this approved no matter what, and he did. And I'm sure that the store has been suffering because I won't go in there at all. But I was simply opposed because of the proximity, and to me, it was clearly not in the right place. This one, I have to say, Laura, you've done a great job with your presentation. I sat and I don't think I've ever done as much preparedness for a meeting as this one, and printed both of them out and went through them, and I have to say her presentation is fantastic. I'm having a hard time. You guys usually equip us with your backup, and this is a tough one. How do we avoid? I look forward to hearing from the public, but I mean, last time we had a desire, it didn't matter, they rolled over us, and that had to do with the zoning because it was commercial. This one is not. But how can you deny that non-conforming or not, we have to consider that. And that is part of our privy that we are to use our brain matter here. And there is a functioning gas station right next door.
If I may, unfortunately, we have to look at the black and white language of the Land Development Code. The language of the code, not what we think, not what we feel, but the black and white language of the Land Development Code. And the code is clear. It states that with non-conforming uses, that's one of the criteria, that you cannot consider that as a criteria for a rezoning case, because with the Land Development Code and the law and the comprehensive plan and the SMART principles of nonconformance, if a nonconforming use goes out of business, basically, the purpose of this is to eliminate or make it conforming. That is the black and white language of the Land Development Code, regardless of how much you may think or feel, but the black and white language is what prevails. Now, if you look at this map, if you look at the map, I do not, with this large review of low-density residential, of MDR, yes, Blue Angel perhaps was a state road, but in that area, it was primarily and predominantly, this was not a flip. This portion was a predominantly residential, low-impact area. And the reason for that is that you don't want to create urban sprawl. That is the reason now. And those are set-aside, smart growth, legally contested principles. With such a large slew, there's no way the county would have upzoned those, because it would have been spot zone. It would have been erroneous, because that portion was clearly, prior to the CCAS study that we was involved in, prior to the map changes that we were involved in, that was clearly R1 or R2. That is low density residential. It was a seamlessly conversion. So and you see all those residential developments that is abutting. You see all those local streets that's there. So I do understand what you may be saying, but based upon the rules that we have to go by, based upon the language of the Land Development Code, what it says, and the competent substantial evidence, that's why staff could not provide the support. Yes, many theories, but with rezonings, we have to look at the language of the comprehensive plan. And now, if you all want to refute that, that's your decision, but we got to go by what the law says, what the code says. Compatibility. Now, it was brought about compatibility. Compatibility is an issue that was referenced inside the comprehensive plan, black and white language. There's a definition for compatibility. And also Florida Statute 163, it states that compatibility, for the sake of consistency, it has to be looked at for intensity, density, and uses. And the definition of compatibility is that if a potential use can have a detrimental impact, so you got the low density, you got MDR, plus it's surrounded by a subdivision, it's surrounded by homes. So we're just not focusing on what we think maybe feel good, but we got to look at what the existing land uses and what out there. So is it compatible? Is it moving towards that? Could it grow? And it's not. This area is premature. Right. It is not grown. So I know the case that you're referring to,
Right.
Perdido Key, but we cannot consider
So,
the legal nonconformance as the criteria.
Right.
We can't.
So interestingly enough, it almost seems as though staff, I'm not saying that, I'm not putting words in your mouth, but it'd almost be preferable to have a home builder come in there and jam, 10 houses per acre on, I'm just saying, by conforming. So I want speakers, neighbors to remember this, and I'm again, I'm not for or against on this. I think this is a very interesting case.
Okay, and
Is
Mr.
to
Powell-
think about what, if you pick your poison, what's going to go next door, whereas currently they're stating, and I know we cannot take this in
Oh, you cannot.
consideration, except for the fact that there's some unbelievably gorgeous oak trees on that back lot that if I were a neighbor, I'd love for them to deed it to my HOA so that we could keep it as a buffer. But that, as opposed to putting in as many houses as, say, a builder could put on that particular spot, that's what would be acceptable, correct? A housing development right there.
But basically, MDR is the residential use. MDR, residential can go, for residential, yes. That zoning category does allow for MDR residential, which is consistent with a DR. That would be a compatible, consistent residential development pattern. That whole area, Mr. Powell, is a residential, much respect for the team, but this whole area is a residential, low-impact area portion, and that's what's on the ground now. And now to come about to try to if it's not planned in that direction, we got to look at right now the future. Yes, her presentation was very well done, but again, she's working for a client. But we have to look at. I got to provide a balance. The Land Development Code, the black and white language, because if there's ever a challenge, I got to be able to support this position, and this is staff position, regardless, we may not always agree, but this is we cannot find what this meet the criteria. It is spot zoning. It's not compatible with the surrounding uses. Now, the future land use category does allow for mixed-use suburban, but we got to look at suitability, compatibility, and what's around there, and preserving the integrity of that area. Those are things that we have to look at when we go to these type of putting commercial right next up to residential. This is what we have to look at, respectfully.
Did you want to add something in there?
I do want to add
If
some
that's
things,
okay
but
with-
I also have first, I would like a point of clarification in Allison's presentations. Under the findings on page 2 of her analysis, the last sentence there, I would like to mention that states, staff determines that the request to HDMU is not inconsistent. I believe she said not consistent, but it states not inconsistent with the comprehensive
should be
plan.
not consistent,
If I could finish, please. I also would like to highlight the definition of infill that is in that same paragraph, which states, infill is defined as development of new housing or other land uses on vacant or underutilized land in existing development areas, which focuses on the reuse and reposition of obsolete or underutilized buildings and sites, which I submit to you, that's what this is doing. That this definition meets exactly what we're doing, so that her statement saying this is not inconsistent with the plan is correct, assuming that definition is what it is, the black and white words, that is what we are doing today. I would submit to you that also the high-density mixed-use district in the black and white also allows for retail sales, services and professional offices, and other non-residential uses. So if a developer came in today and did want to clear the entire parcel for non-residential uses, as long as that development met the requirements of the code, it would not even be before you. It would be approved on that merit. So I just want to accentuate what Mr. Pyle was saying, that somebody could come in and clear this whole 6.6 acres. That's not what this developer wants to do. They want to do what's right for the community. They want to keep that buffer behind, so that there is not an incompatible issue going on here with the adjacent residential uses.
And just for the sake of clarification, to correct the record for the Land Development Code, MDR zoning does not allow for commercial development. It does not. So the only thing that would be consistent with compatible in the MDR zoning category would be a residential development pattern. Yes, it should have been not consistent. That was thank you for the correction. Not consistent. So an infill development, yes, it is a tool that we look at all the time. But you cannot have, in this area, infill that is sporadic. You just can't have sporadic infill. If there was a logical development pattern of commercial infill development, perhaps that could be a consideration. But again, that store that's been there a long time, basically that's a non-conforming use. And that whole area, if you look at the maps, the existing land use map, the area map, we did observation out there. I'm just saying the suitability of this parcel of land, Mr. Powell. That's all I'm saying. So MDR right now, you cannot clear it for commercial. MDR allows for residential uses only, and the high-density mixed use, we're just not focusing on the store. We're focusing on all the potential uses and the densities. the densities is a challenge as well. So that's what we're looking at, respectfully.
Staff, can you put up the use, the allowable uses for HDMU? Because that is what we ultimately are looking at. I can't say that this board cannot take in consideration for a singular development on
And
this. We
those
have
are
to
also
consider
in the
all.
findings too.
Put it up, yes. Thank you, Mr. Van Horn.
I mean, because ultimately, at the end of the day, we're talking about the entire 6.59 acres here.
Horace, the applicant alluded to the fact that upon initial contact with the county that they were looking at going to a commercial for the rezoning in this case, and were told by staff to go to HDMU. Does that sound accurate?
I wasn't aware she said it was, yeah, yes.
Yes, sir. She came in and she provided an application for commercial. And then once the division managers and the senior planners, we all looked at it, and the commercial was more intense in their uses, and the commercial uses are way more intense than the current MDR, LDR in the area. So we suggested that they could do the, go down to HDMU for their request for rezoning versus commercial.
Right. But
Ms.
there's,
Mills, was it your understanding that by that recommendation provided by staff that you would maybe get a more favorable opinion in what you've gotten from staff today?
So knowing that they can't make a promise to a decision a board is gonna make, but we've had discussions for months. So this wasn't a decision to apply on November 20th, and then we were having discussions prior to that. And the original discussion was to apply for commercial, and understanding that there might be some concern with the intensity of that use, and that therefore at a public hearing, then we could downgrade to the HDMU to help appease the situation. But once we applied for commercial, then the thought process changed, and we were asked to change our application to HDMU, which is what we did.
Okay.
And for those of us keeping score, after the clarification on criterion A, we now stand at 0 criteria being met of the 5.
basically at this point, we looked at this very carefully. We looked at it very carefully, and they mentioned about subdividing the property. Again, that's why we don't want to get into site specifics. We looked at that. To do that, that's why we have to look at the whole gamut of the code. We cannot create non-conforming lots when you're subdividing. So all of those things was looked at. That's why, but we don't want to get into those details right now. But they mentioned that would have been some other challenges would have occurred. So
Which is a little confusing to me, because we never indicated we would create a non-conforming lot. We were going to leave enough egress and ingress and egress on one side to reach the back portion.
but again, it was stated they want to split the lot. And when you split lots, you got to create non-conforming. You got to create everything. But that's not neither here nor there. So I just want
Yeah.
to say for the record, since they brought it up.
Okay. Are there-
Aside from that, before we hear from the public, for their sake, I know you see a sign go up, you're concerned, there's something new coming, it's going to change life, I want to go talk about it. As it stands right now with the current zoning, a housing developer could target that property, purchase it, and build 60 homes as long as it was compliant with BOA.
That for a subdivision, that would be the gross density.
We
MDR.
we
So
get
just-
that.
We want to be clear.
Infrastructure, all that, so I get that, retention.
We want to be clear.
50, 40, 50. I'm going to get, as a developer, the most houses out of it that I can get. And I can get 10 DUs right now with the zoning.
Let's be clear with words is very, very important. The zoning, the gross density does allow for that. But whether or not they could get that,
Yeah,
we to be clear.
understood, granted.
That's another,
Granted.
we weren't clear, so, okay.
Definitely more than 6,000 square feet worth of home, and car traffic would be more. But anyway,
I cannot say that because you can. So let's be clear. Those are things that's speculation, so we want to be clear with the record.
All right. I'll let you add something before we go to
Yes,
the
sorry,
pub-
I know I
public.
should
No,
have
you're
just
good.
jump up. Thank you. If we failed to include anything, I take full responsibility for this. It would be the site plan in our application, and I do think it's critical for y'all to see it. So if I could enter it for the record,
So I'll say this, we can have a vote on that. It's not something that we can
Yeah,
use
sure.
in evidence to make our decision today,
Yeah.
unfortunately. But if the board wants to look at it, we can do that, but it wouldn't be anything that would
Okay.
really hurt or help your case, to be honest.
The intent would just simply be to illustrate the property that would be deed restricted to green space, so it could never be developed. And that's what the site plan reflects. It shows our 2.5 acres in relation to what would become the 4 acres of green space. Deed restricted, or I love the idea of deeding it to the HOA if that was appropriate.
Board.
I'm sure the board is
Direction one way or
aware
the
that the board cannot consider any site plan or anything like that for their decision. For that reason, I'd advise that it shouldn't be entered into evidence unless the board.
Don't do it.
That's fine. Yep.
I appreciate it, but
Yeah.
again, it won't help you or hurt you
Yeah,
one way
I
or the other, so.
understand. If this goes through, it will happen, I'm a
Right.
man of my word. Thank you.
All right. We'll move on to the public unless there's any other questions up here, which I don't think there are. And for those members of the public who wish to speak on this matter, please note that the planning board bases our decisions on the approval conditions and exceptions that we've described earlier, those 5 criteria. And during our deliberations, the planning board will not consider general statements of support or opposition. Accordingly, please limit your testimony to the approval conditions and exceptions described in section 2-7.2. And please note that those individuals, only those individuals who speak here today will be able to speak at the Board of County Commission meeting when they make their final decision. So if you haven't filled one of these out, which I would imagine that you all have, if you're wanting to speak on this, we do have more forms in the back of the room. As you come forward, I'll ask you to state your full name and address for the record and be sworn in. So we've got David Cohen is our first speaker today. You'll have 3 minutes, and just name and address for the record and be sworn in.
My name's David Cohen. I live at 5780 Scotland Court.
Raise your right hand. You solemnly swear or affirm the testimony about to give in this case be the truth, the whole truth, nothing but the truth, so help you God.
I do. Can we put my address up there so you know exactly where I'm talking from? On Scotland Court, up in the corner, over, keep going over, right there. That's my house. I bought that back in 2008. Been there for quite some time. When we were looking around at the house, we noticed the whole backyard was nothing but woods, and thought, hey, this is great. This is where I want to raise my kids and my grandkids. We raised our grandkids there. Took them out in the woods, did all the stuff you do. We've got a pool right there in the corner. And that was the thing that when I looked at it, I said, okay, this is good. But one day there could be houses, and I could accept that. But now with this, if they put the Dollar General there, and you go out in my backyard, there's a pool, and there's Dollar General. Nobody's going to want to ever buy that. It's just not an investment that you want to make because of how it affects your property value. And I Googled it, and it said Dollar Generals tend to make property values go down 16 to 21%. So that's my displeasure with that. And putting houses in there is going to make my property go up, because that house in 1973, when it was built, sold for $26,000, and I just refinanced it, and it's worth $220,000 now. So it's a significant investment that I made, and I hope to continue that it grows, so that when I retire in about 5 or 6 years and go to sell it, that it'll sell based upon being a residential area and not a house that has a Dollar General in the backyard. And that's really, to me, the big issue is putting that there, because there is a Dollar General 1.7 miles down on Softly Field, and then there's another Dollar General 2.7 miles down off Lillian Highway. So we have enough Dollar Generals. And to me, it's like, leave it as it is. Because we also, we raise birds, parrots. They have a very susceptible respiratory system. And if all of a sudden we have diesel 18-wheelers coming into the back of a Dollar General and leave their engines idling, that creates fumes that can drift over into where we keep our very expensive birds that could be susceptible to that. We are licensed. We have a Fish and Wildlife permit to raise the birds. We pay taxes on our income that when we sell the birds. So it would kind of be affecting us that way also. That is a retirement income that we're slowly building up, so when it comes to retire, we can fall back on selling our birds, because we do ship them domestically across the country. We advertise on the internet, and we get buyers from all over the country. So because of that, it would be detrimental to affect it so that we can't do that anymore.
Thank you. All right, next we've got Sandra Gold. If you could please state your name and address for the record and be sworn in.
Hi, Sandra Gould, 5780 Scotland Court, Pensacola.
Raise your right hand. Do you solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Hi, I'll just kind of expand on what David said. Okay, I'll just expand on what David just said. I'm his wife. We live at 5780 Scotland, so you see we're right, this is abutting our property. We bought this home 17 years ago. Our plan was to, like he said, raise our family. We've taken on 4 grandchildren that we've had to take custody, and I'm adopting my youngest one. This is where they're growing up. Putting a Dollar General in there concerns me. I have some people that I know with other Dollar Generals and what it brings to the area in terms of traffic. A lot of things, I'm not attacking Dollar General, but any business of that nature and that size, undesirable activities, just a lot of things. We're residential, and they want to highlight that, oh, we're not going to develop the back 4 acres or whatever. I'm abutted right up at the front to that. This is going to completely impact my life. The small income that I've started generating so that I can raise my family. And, we retire in a few years. I've invested a significant amount of money into they were a hobby, but now they're a small business as well. And I work on conservatory breeding as well for endangered species within the Florida Fish and Wildlife Commission's guidelines. I've got all my permitting. I pay city and state tax, but it's a very small level. But this is what's going to allow me to survive and allow me to finish raising my family. And intentions were for our oldest granddaughter to get out of the Navy and buy the house from us in a few years. This is upending everything. Quality of life in our neighborhood is going to change. They can say they're not going to develop it back there, and I don't know what the intent is or isn't, but what safeguards do I have to keep people from crawling over a tiny wall they might put in that's going to look right into my pool with my children in it? And what about I've been there 17 years. That little teeny convenience store they're talking about is tiny with 2 pumps. It is not anything substantial. It's just a little convenience thing that's been there for a very long time. I just think that they're encroaching on what's intended to be a residential area. I have no problem with a residential neighborhood going back there. Lord knows we all need more housing space in the city. So, but single dwelling, you don't need huge 6-story apartment buildings back there, all that. What about those of us who are right up there on the circle? We pay our taxes. We abide by the laws. When do we get considered? So it's a little bit of an emotional thing with me, but that's where, I stand.
Thank you. All right, next we've got Richard Grimmel. Please state your name and address for the record and be sworn in.
Richard Grimmel, 1570 Scotland Court.
What was it again?
5790 Scotland Court.
Thank you. Raise your right hand. Do you solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, thank you. Gentlemen, first of all, I want to bring to your attention, looking at this notice that we've got, it went out only to the homeowners that are 500 feet what about the rest of the subdivision that's gonna be impacted? Back in 1996, this exact same property was up for housing. It was stopped because, again, myself went and talked to every single neighbor, got them to 63 people to show up at the meeting. Sorry. The main thing that held it up is the traffic. The main thing that they could not do is they told them they had to have a traffic light there, and the owner that bought the property did not want to pay $100,000 for that property, okay? The other problem you've got is that is a flood zone. All these houses behind David and Sandra's, going all the way down, water's like a river coming down the back of that property. I understand they're gonna try and put a holding pond in there. There's so much water that goes through there, it comes in waves about 2 feet back side of the houses, okay? So that holding pond, even if they do put a holding pond in there, what's gonna happen when that overflows? The street behind us is at current, those homes are being flooded, the water's going right straight through their garages, okay? So looking at it, I'm trying to get some idea of what's going on. My house was paid for. I bought that house back in 1978. It isn't going to be my retirement home. I'm 75. Have no intention on retiring yet, okay? But I just wanted to voice my opinion. Just, there's going to have to be a traffic light. If you're coming down from Pine Forest Road, you're heading towards the naval base. To get into our subdivision, they have moved the street out 14 feet because people were coming down, hitting the sign that said Yorkshire Estate, which is our subdivision, broke those brick walls, and kept running into the house there. That's why they moved it out. So meaning we have got to come down from Pine Forest. That is a very hard turn coming into our subdivision, slowing down, hoping you don't get hit. The worst problem is coming from the naval base. If you go to turn into our subdivision, you are turning into a turning lane of cars going to Cerny. Well, we've got to get in there to our own subdivision. We're in that turn lane for the oncoming traffic. So something's going to have to be done there. There's already been 3 young ladies that were killed there with a truck coming in from naval base that the girls were in the turn lane, hit them and knocked them all the way into our subdivision and killed them. So these are things we need to look at.
Thank you, Mr.
Traffic
Grimmel.
and with traffic lights.
Yes, sir.
Thank you.
Thank you. Next, we've got Bradford Grimmel. Please come forward, state your name and address for the record, and be sworn in.
Bradford Grimmel, 5790 Scotland Court.
Raise your right hand. Do you solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Some of the same concerns with traffic. As mentioned, if you, from Scotland Road out in Blue Angel, if you're trying to exit the neighborhood, right now, traffic is already an issue. You know, we talk about what could become more of an issue, but it's an issue right now. It can easily take you 10 minutes to get out of the neighborhood. Coming into the neighborhood, taking a left, there is no turning lane. So it's already dangerous, as we just mentioned, where you're trying to cut across oncoming traffic, you're in their turning lane. There was some past history discussing a traffic light, so if we add, a Dollar General, yes, that's some more traffic. How much worse is that gonna make that? Also a little concerned about these 4 acres in the back. If the high-density zoning then allows apartment, 10 units per acre to be put there, then that compounds the traffic even more so. So just concerned the hazards and what that's going to do to the area from mainly a traffic perspective. Then that's pretty much what I have. So.
All right, thank you. I think I skipped over Linda Sagman. Sorry, I just realized that, so I'll get you up here next. If you state your name and address for the record and be sworn in.
Linda Saman, 5620 Cerny Road.
Raise your right hand. Do you solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. My family has lived on Cerny Road since the 70s, and I've seen it grow and grow in that area of Bellevue. We are in low-density area, and we are surrounded by medium-density area, and I really do not want high density in this area. I enjoy living in my pleasant, low-density residential neighborhood, and I'm concerned that the rezoning will change the character of the local area. This rezoning will bring more people, more traffic, safety issues, and more noise. It will also decrease our property values, and this zone will significantly impact traffic. There is a deadly corner within a few yards of this proposal. The traffic is already congested in this area. Please do not allow the zone change to high density. Thank you.
Thank you. Next, we've got Andrew Bluer. Please come forward, state your name and address for the record, and be sworn in. We'll get your time started.
Andrew Bluer, 6101 Midas Place.
Raise your right hand. Do you solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, nothing but the truth, so help you God?
I do. Good morning. I'm here basically to hopefully talk y'all in not rezoning anything. I don't want you to rezone anything. The stupid mistakes that the county has done in the past is going forward. All right, Blue Angel Parkway, when y'all did all the rezoning on that, why wasn't that zone commercial to begin with? Because y'all went through Softly Field or whatever and zoned all that on Softly Field commercial. And y'all came in there, okay, they came in there with the Dollar General, and the DRC didn't do anything that they should have done. So everything, y'all say, oh, we did our part or whatever, then the DRC, you've got Horace here or whatever, and the county staff or whatever is doing their part to help people out, I guess, but it ain't helping out the citizens in there. If you look at that Dollar General on Softly Field and Muldoon, totally messed up. That's a residential area. They put the Dollar General in there because somebody rezoned it commercial, and y'all didn't have a say in that because that was back in the 90s or whatever. You said, oh, Softly Field's commercial. Let's do it commercial. All right, if you go in there and look at that Dollar General, the holding pond is way too small. The driveways are too close to the intersection. They got trash heap in the back of the Dollar General there that degrades the value of everybody. I mean, they got, I call it a trash heap. I mean, it's like bread racks. I mean, how can they have so many bread racks or whatever it is? The trucks pull in there and dump off their trash there. Nobody wants that there on Blue Angel. The traffic on Softly Field, that should have been 5-lane on Softly Field, just like they got, you got Michigan comes there, and it should be 5-lane on Softly Field all the way to Blue Angel. The county says that ain't their road. So what are we going to do? That's a state road. I think it's supposed to be a federal road. But the county hasn't negotiated anything with the federal government or the state to fix that road. How much money have we spent on Blue Angel Parkway having traffic survey on that? I don't know how many millions and millions of dollars they've done on Blue Angel Parkway. Is it 5-lane there on Blue Angel? No. I don't think anything should be rezoned commercial or on Blue Angel, but it sure is that way now. I mean, the only part that's 5-lane or 4-lane or whatever is down there by the back gate of NAS Pensacola. So I say nothing needs to be rezoned, and let all these here real estate lawyers go to the Board of County Commissioners and say, hey, get off your hinds and get this here county
Thank you, Mr. Bluer.
situated the correct way.
Thank you. Chris Kerb, we'll have you up next. If you just state your name and address for the record and be sworn in. And that was the last person I had signed up for this case. I didn't know if there was anybody else. Okay. Are you Mary Konopka? Okay. All right. I'll get you up here next. All right.
Chris Kerb, I'm with Flood Defenders. I previously,
Let me get you just sworn in real quick.
Raise your right hand. You solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God.
absolutely, I'm all about the truth, brother.
And your address, Chris, and then we'll get your time going.
My address is 5999 Somerset Drive,
Thank you.
Pensacola, Florida. I would like to remind the board that I think at one of the former rezoning meetings, I was certified as an expert in stormwater and engineering, for the record. I just wanted to make a real quick comment. I'm not for or against this, but I did want to make some comments on some history about flooding in this area. And I already know the response, because I hear it all the time, is, oh, that's going to be handled by development review process. Well, if your development review process doesn't allow the public to come in an initial review and make comments or a final review, then how is it going to be addressed? There is some historical flooding on Perkins and Turkey Road, which I believe is down gradient of this property. Under your section E, this little handout y'all put out, it says, appropriate with changed or changing conditions. If your land use development conditions within the area surrounding the property of rezoning have changed, the changes are to such a degree and character that it is in the public interest to allow new uses, density, or intensity in the area through rezoning, and the permitted uses of the proposed district are appropriate and not premature for the area are likely to contribute to sprawl. Public interest is what I wanted to point out. Stormwater, flooding, and drainage is public interest. I actually think y'all's rules should be revised because you just had a rezoning get kicked back for the third time on Bellevue because of flooding. So that was zoning case 2024-11.
We'll just stick to this one today, if that's all right, Chris.
Well, you know, case law, quasi-judicial systems, you can rely on other cases. Am I correct, attorney?
The board can look at its previous decisions in some capacity, but each decision is independent and fact-intensive.
Okay. Well, I just want to get that on the record, too. Thank you.
Thanks, Chris. All right, next we've got Mary Konopka. If you could just please come forward, state your name and address for the record, and be sworn in, and we'll get your time started.
My name is Mary Konopka. I live at 6248 Muldoon Road, Pensacola, Florida, 32526.
Raise your right hand. Do you solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God.
I do. Clock going? I'm here to back up the residents in the Bellevue area, especially those that have been there a long time. They purchased their properties with lots of room around them, woods behind them, little traffic, and we love it. That's why we bought it long, long ago. And now it just seems like developers are snatching up every little piece of land they can find to build stuff on. And that is, the traffic's horrible. It's gotten horrible. The flooding's gotten worse and worse and worse. So many impervious surfaces now. The water has nowhere to go except inside the houses, or swamping yards so your septic tank doesn't work. So I do stand behind these folks here. I bought there a long time ago, and that's why I bought. Lots of room, woods. I love it.
Oh, do we have another speaker? Just like. You?
Are you with the applicant group, sir? Yes. Okay, so we probably have a pink sheet on you. Philip Walker? No?
That's Gary Watson.
Gary Watson, sorry. Oh, Gary Watson. Yes.
Yeah, we got you. Here, yeah, I see.
Gary Watson, 1308 East Barcelona, North Barcelona Street, Pensacola, Florida.
Raise your right hand. You solemnly swear or affirm the testimony about to give in this case will be the truth, nothing but the truth, nothing but the truth, so help you God.
I do. I'd like to point out something that's sort of the foundation of this whole problem. Yeah. Okay. The root of the problem here, in my opinion, is if you go back in the records and look at the convenience store, it was built in 1973. Zoning went into effect in 1988. The county at that time zoned it something. Today it's called LDR, even lower density than medium density. If that convenience store had been zoned properly when the zoning went into effect in 88, we wouldn't be having this conversation because it would be a property adjoining another commercial property. So I say you need to fix something that was broken a long time ago. Thank you.
All right. Thank you very much.
Can I? Yeah.
Well,
I guess we have him.
yep, Josh.
If I may, again, Josh Huffstetler. I just want to take the opportunity to reiterate to the community behind me that I would love to speak with any and all of you after this meeting, and I've got some great ideas to preserve the green space as we've discussed, to modify our plan in a manner that appeases you as much as possible. I do understand that that's an impossible task, but I can promise you I'll do everything that I can because the next developer may not. And so all I ask is please take the opportunity. Thank you.
All right, thank you, Josh. Board, are there any questions that we've got for staff or the applicant or even members of the public at this time?
Mr. Walker, I want
Yes,
to
sir.
say something very, very short. The density is an issue. High-density mixed use will allow for 25 dwelling units per acre. Mr. Eric, you stated that if they stay with MDR, if they go to MDR, if they go to HDMU, that allows for more density. It's a multifamily, allows for apartments as well. So that's why we just can't focus on this one use. We have to look at all of the potential uses and the black and white language of the Land Development Code when considering these rezonings. Thank you.
And Mr. Speaker, to Mr. Fear's point, though, currently as it is, it's 10 per acre, correct?
Correct.
So, and I understand, and you're right. It could be 25 per acre. The public, the developers just offered, I just think it's interesting that, look at who you've got on hand now, and he's correct that the next guy may not take such a position.
Jonathan?
Do we have any sewer infrastructure maps for this?
No, sir.
I don't know, but in these type of cases with the rezoning, that is a site-specific issue, so we need to stay with
Blue
that
Angel
too.
has sewer.
Okay. Public water and sewer. And this would be tapped into sewer.
All right. Any more questions for applicant or staff at this time? If not, then is there anything that staff or the applicant would like to add to their testimony? Okay, then I will entertain a motion to open up discussion one way or the other. Anybody would like to take a stab at it?
I mean, I'm gonna keep going back to the zoning overall here. I mean, we cannot look at the actual development. We have to look at all possible things with HDMU here and with this map. And that's what's throwing me off. I know that there's a logic here of the existing convenience store there. And it sucks because we've had similar cases in the past, but the problem is they were next to zoning that was compliant. And this up through this one, I don't have a good answer here. The whole blocks are MDR, LDR. And once again, we can't go by the existing use that's in the code. It's not an ideal situation on a few fronts, I'll say that. But I go back to the zoning map here. That's what's driving my decision, I'll say that. I don't know about anyone else.
Jonathan, you got your light on?
Yes, I make a motion, we follow staff's findings and deny the request for upzoning.
Okay, we got a motion. Do we have a second?
Second.
Any discussion on the motion?
Pardon the interruption, but I'd
Yes,
like
sir.
something clarified, that the staff findings, there was a typo, that in the motion, that it's clarified, that it is, it's not supposed to say is not inconsistent with the comprehensive plan, to say is inconsistent with the comprehensive plan, to clarify that when, if the staff findings are adopted.
Thank you.
All right. Okay, discussion on the motion to deny the upzoning request. All right, all those in favor of the motion, please signify by raising your right hand. All those opposed, motion carries 4-1. All right, that, is there anything further from staff for this meeting? Or we'll adjourn this and move on to the regular board meeting? All right, we'll take a 5-minute break real quick. A 5-minute break, and then we'll start the regular planning board meeting.
Saw they put my earphones on. They were so small. Just you and John. Let's talk to County John. Let's talk John.
Are we ready? Are we?
We have wait for staff's partial. We have another speaker.
All right, ready to go? All right, this meeting of the Escambia County Planning Board for January 7th, 2025 is hereby called to order with 6 members present. We do have a quorum. Do we have proof of publication?
Yes, sir.
Did the publication meet all legal requirements?
Yes, sir.
I'll entertain a motion to waive the reading of the legal advertisement.
Motion to waive the reading.
Motion, do we have a second?
Second.
All those in favor, please signify by raising your right hand. All those opposed? Planning Board meeting minutes for December 3rd, 2024 have been provided to the board members previously. I'll entertain a motion to approve the Planning Board meeting minutes. Motion, and do we have a second?
Second.
Second. All those in favor, please signify by raising your right hand. All those opposed? The Planning Board hearing package for January 7th, 2025 has been provided to the board members. I'll entertain a motion to accept the board hearing package and legal advertisement into evidence. To have a motion?
So moved.
To have a second?
Second.
All those in favor, please signify by raising your right hand. All right, and today we have a public hearing concerning the review of an ordinance amending Chapter 1, Article 1, Section 1-1.2, stormwater quantity, and Chapter 1, Article 1, Section 1-1.4A, pond slopes, fencing, and maintenance access. So we'll turn this over to staff to run us through this, and we do have a few speakers that have signed up for this today, so we'll get to them once we get through this presentation.
Good morning.
Morning.
I'm not going to try to read that to you, and you can thank me later. But the reason we're here today is because we've been meeting with our PAC, which is the Professional Advisory Committee that leads into your board. In other words, we meet with our PAC group, who are resident experts appointed by, and they listen to the citizens of the community that are interested in these topics, and they make recommendation for us to go forward with any modifications to code. What you're going to see today, let HDR do a presentation for you of what we summarize to these changes, and then we'll go forward with any further discussion after that. So I'll let Alan take over from here. Y'all introduce yourselves.
Yeah, Alan Vinson. I work with HDR Engineering. I've been with them for about 20 years. Been doing
stormwater and transportation work for the county during that same time frame. I'm joined by Philip Walker, who's been doing the same for about 10 years. We do a lot of stormwater work for the county. So the purpose of why we're here today, engineering staff asked us to kind of help define what it is we're talking about when we look at the current DSM language, and we start talking about things like old DOT rainfall data, NOATLAS 14. What does all that mean? So the two items we'll talk about is the FDOT-IDF, which is the old way of quantifying the amount of rainfall that falls over a certain duration. When we talk about 25-year and 100-year designs and that sort of thing, and then the change to NOATLAS 14. These are both statistical methods for determining the amount of rain that falls. So we were asked to review the impact on county stormwater pond design. And so we put together a report that went through several different alternatives, several different land uses, several different soil types, wet and dry ponds, to determine what the change to NOATLAS 14 would require of county stormwater pond design in the future. So we're going to go through some comparisons, and ultimately we made recommendations into that report to look at some specific elements of the DSM, and we made some recommendations there. So it's really a matter of best available science. When you look at the FDOT-IDF curves, they were created in 1979. They were based on data and technical reports that were created in the 60s and 70s. Those reports contain stations, rainfall gauge stations from only 9 locations in Florida, and most of those were situated in the Miami and Jacksonville area. DOT archived this data in January 2024. Next slide. So NOATLAS 14 it has a broader reach with regards to the data that creates these rainfall values. The stations are in 6 southeast states. There's nearly 3,000 of them. There could be 3,000 by now. The records encompass from the 1800s all the way to 2011. The DOT drainage manual from 2020 to 2023 adopted the use of NOATLAS 14, but still included the old FDOT-IDF curves, which probably caused a little bit of confusion, but they still included that whole information appendix because that's kind of the way we always done it, right? And then in 2024, those old IDF curves were removed from the manual, and they've now been stamped, archived, not for use in design. So really, when you consider the two, NOATLAS 14 would represent the best available science just based on those statistics. So the way it works is, you take a dynamic point anywhere in the county, and it'll provide you. NOAA's website will provide you with the rainfall values for different storm events and different durations. And so, for comparison, the archived rainfall information for a 100-year, 24-hour event, you see it's roughly 13.44 inches is what's been historically used. Under the new NOATLAS 14 rainfall data, that would go up to 16.2 inches. And so what we're saying there is, by adopting this pond design, would when you're looking at that 100-year, 24-hour event, would go to a 16.2 inch rainfall amount at that specific location, which for the purposes of this example was a point taken along I-10. Continue. So what we did, like I mentioned, is we ran several scenarios to see what the impact would be on county stormwater pond design with that increase in rainfall value. So for dry stormwater ponds, you see it represented, an 8 to 10% increase in pond volume across all the different scenarios we ran. 6 to 15% increase in volume for wet ponds. And the biggest increase was for dry, closed basin stormwater ponds. Those are ponds that don't have an outfall, and so they have to be larger in order to attenuate or capture all the water that would run off to those sites. We saw the biggest increases there. So, in summary, again, the idea here was to kind of define the two methodologies and what the best available science is. Ultimately, we want to use the best data available. That it also provides the county with national consistency on what the rest of the nation is using. The old IDF data hasn't been updated in 45 years. It's already been archived by the state, and it obviously provides a higher level of resiliency, when you consider future development. It is also logical, they haven't stated this yet, but it's logical that federal agencies in the future, when it comes to grant funding, would require this national standard to be utilized. So with that, I just kind of wanted to give you an overview of kind of what's probably the biggest question mark in the proposed changes to the DSM. Define some of these terms. If you guys have any questions, feel free.
I do real quick. So basically, let's catch up to science, right? Let's adopt this, and you're making this bigger. Is there anything that we can do going forward to help with handing off said subdivisions or developments with maintenance? Because everything is about the pond, the size, how that water is treated from point A to point Z. That's great. Everything's perfect until you hand it off. Developer sells it, he's gone, and then you've got an HOA sitting around and have never heard of what they have to do to maintain a pond. I saw the first big stick cleaning out a pond the other day. I almost went over, I wanted to hug the guy, and I was like, who told you to do this? I don't think, in other words, that we're equipping homeowners or subdivisions with the knowledge or how to maintain and keep these things. And I'm in a subdivision right up next to Intercoastal, and somebody asked me, where's that water coming from? I said, really? And anyway, so to me, I just think that's something that we've not done a good, again, I'm not blaming you or anyone else. How can we incorporate it into the building development process for maintenance and upkeep going forward?
And good morning. Again, I don't think I even introduced myself, and my apologies. I'm Joy Blackman. I'm your county engineer. And that is a particular problem that we've been dealing with through the years. A lot of the privately maintained subdivisions, I prefer that they're adopted by the county for maintenance, and we've tried to encourage that. It's still, occasionally there are some that remain private and are required by HOAs to maintain. The answer to your question is a little more complicated, but the good news, I suppose, is that the Water Management District is requiring an operation and maintenance letter to be signed by those HOA so that they understand the cost annually and the necessary methods that are needed to maintain the pond. That's just now beginning. Through this year and the new water quality rule that's coming in next year, it'll get even more complicated. But as I say, I prefer that even if there's, you'll see in this where we're no longer requiring that they remain private just because they don't have a positive outfall. I would prefer the county take maintenance because we know what's required. We have the MS4, which is a permit that's countywide that we have to maintain with Water Management District. So it's better that we do it that way. We're held accountable by them, and we have the equipment and the ability to do so. The pass over to the HOA as it existed in the past was a generic letter, not something that truly gave you background and information that would be much help. So presently we work with any of those that are private and try to convert them. But to answer your question, it usually comes down to a code violation. If you're noticed of code issues with your ponds, then we sit down and meet with you and try to bring you up to speed as to what's necessary. Perhaps when I say we convert them, Mr. Powell, that means we have the MSBU process, which means we can establish you as an MSBU in your subdivision, and we can tell you what it's going to cost for the one-time maintenance, or we can tell you what it costs for maintenance in perpetuity, and you can establish that, agree to an assessment for that if you want to do it. So it's a little complicated, and I don't have a good answer at all for those that are in the past, but I know that what's coming in the future is the notification of this, the annual reporting that's going to be required for our Water Management District. It's going to enforce it whether we like it or not, but of course, you know, we want good stormwater, we want good water quality, so it's putting a lot more onus on the developer, on the county, and if it remains private, on the HOAs. So there'll be more information. Sorry, not a short answer.
Backing up from that question, just for my clarification, if the new quantity goes into effect, that's future design only, does not retroactivate any existing pond maintenance or design, or when we go in and dredge the floor and put a new floor in, are we under the new compliance standard?
Good question, thank you. It goes into effect as the BCC approves it, and not retroactively. It is for any new developments from that date forward. There've been a lot of discussion back and forth. We've probably vetted this particular item for almost a complete year, probably 3 to, I'm going to say 4 PAC meetings alone just to vet this item. The BCC has not given exact clear direction as to which way they were going to land, so I'm still waiting to see how they vote. When they vote, then I'll know. But to my expectation is that it will be adopted by the BCC, and upon that date, it will become effective. So any development that has not submitted an actual DRC application will have to comply with this requirement. I have some latitude and have used that latitude in places where we know we have drainage problems. In the history of Escambia County, that was not something that was available, or not something that was used by previous county engineers, and myself included, because the board's direction was not very clear. However, that is not the case any longer. We have some latitude, and for instance, if there's a development coming into an area that I know is problematic, we will require them to do additional, because these guys, as engineers, know. I will tell you, yes, you want to use the best data available, the best science, but nobody was trained to do it to the minimum standard. As an engineer, you were never trained to do minimum standards. So I will sit with them, and we will have these hard conversations about, I'm not going to be able to approve this without you going above and beyond, because I already know I have a problem. And it may not be to your benefit to go forward with this project, but I can't, in good conscience, allow anything to go forward if they don't go above and beyond and do what's necessary. So these are minimums, and that's just what I want to say for your benefit, for the other things that you're hearing here and there, that you know that's not all that's done is minimum standards. These engineers are ethical, and they're doing their job best of their abilities.
From a pre-existing condition issues, I know staffing has always been challenging in the engineering department, as well as anything having to do with public maintenance here, public works. The pre-existing problems, like Tim was referencing, I live in a neighborhood that has a HOA maintained ponds, plural.
Right.
The change in leadership within HOAs happens, could happen every 2 years, could happen every 10 years. The education for someone new here, they want to be the HOA president, they don't necessarily know who to reach out to. I happen to live next door to my HOA president, so I get lots of questions about maintenance on their ponds. From an outreach standpoint, because pre-existing is probably the biggest problem that we've got, because going forward, obviously, we're looking to upgrade our standards and build to accommodate, current floodwater data or stormwater data. From an outreach standpoint, and not to put another thing on your plate, Joy,
That's
but
all right. My brain's already spinning. Go ahead.
From an outreach standpoint, how could we, as the planning board, assist staff in sending something to the Board of County Commissioners that would help you outreach to existing neighborhoods and homeowners. Homeowners just in general, and homeowners associations specifically, and the presidents of those homeowners associations that have existing ponds in place that they should be maintaining. What would help staff facilitate that? Obviously, money's.
Well, thank you.
Throw money at it's typically the answer.
It could be, but I mean, some things are available to us just by doing a database search. So that, you know, through our database, we know which ponds are private in terms of subdivisions. I'd like to separate subdivisions from commercial sites completely, because that's just
Whole
a
different
whole
ballgame.
different devil and a whole
Yep.
detail. But the subdivisions, we know which ponds are private, and we could make efforts to, you know, put together a package of education, because through our MS4 permit, that's some of the things that we're already mandated to do by the state. So that's, you know, you started asking the question, my head started spinning a little, but it's certainly something we can do through that permit, and we can notify the HOAs of what's necessary, and also tell them what options they might have. Like I say, if we wanted to convert them to public ponds, I'd much rather do that. And, you know, the Public Works Department will have a little bit of a concern with that, but by the same token, it's best in the long run for the county, because most HOAs don't hold up through 20, 30 years, and by the time we get to that point, we need to take it over, and maybe we can improve it, expand it, deepen it, do things to make it serve us better in the long run. There's ponds in some subdivisions that were only built to treat a half inch. You know, that's
Right.
simply not enough. It's simply, there's flooding, and if I can get into those areas and perhaps expand the pond, now that's another problematic issue, because that means I'm buying houses. But by the same token, if they're flooding and repetitively flooding, and we can buy the home and expand the pond areas, then we're doing a lot of good for everybody in the neighborhood. But to answer your question, I'm sorry, it's a topic that we could get into through our education program on the MS4. We could put together informational packages and make it available to those private subdivisions.
Yeah, even just something that was in a digital format via a link that,
Yeah.
because every one of us up here is in real estate in some form or fashion.
gotcha.
And goodness knows, people find out that you're on the planning board, they want to talk to you about all kinds of stuff. So if we could direct them to something on myescambia.com, here's option A, option B.
Right.
You know, you can, this is what you can do on your own with the assistance of
Okay.
Escambia County Engineering. This is something that, you know, option B is MSBU, which obviously you've recently had to do that with some projects where the homeowners in that subdivision get to, you know, bear that through an MSBU. But if we had something like that to communicate out to the citizens and any, you know, everyone, the county commission as well as the planning board, anybody that gets questions that
Okay.
could help
I'll work with,
educate through something through the public information office, that would be great.
We can do that. We'll put together a package for the MS4 related project, and then we'll pass it on and make it available to you guys. We'll get Rachel to follow up with us on that.
Awesome, thank you.
I just want to add one thing to that, and it's more of an idea. I was formerly a neighborhood association president in the city, and the city has a Council of Neighborhood Association Presidents, CNAP they call it, and you know, it is an opportunity for neighborhood association HOA presidents to get together into a common forum, and I feel like something like that would be a good way to educate, you know, kind of president. There could be like again, a site set up on the county website for it. The county can post information, questions could be asked. You know, county staff could potentially be available at like an annual meeting or something like that of those groups of presidents. So just a thought.
We'll work towards something.
All right. Anything else? Okay, we'll go to public comment, or I guess comments speaking on this issue here. Mary, I think we had you up to speak for this. Just state your name and address, and then we'll get you started.
I'm Mary Kanopka. I live at 6248 Muldoon Road in Pensacola, right by Hogan's Pit. And what I'd like to know is this, I have a lot of questions. This application that y'all are talking about, who developed it? And I know they talked about the FDOT stuff, but in this application, are there going to be berms? Are all of them going to have outflow or not? Those are some questions, because those that don't have any outfall fill up and they flood surrounding areas. I don't understand the berming, and I would like that explained. If it's a new design, is there somewhere else in the county or country that's using this design, specific design with, I understand there's berming and stuff in it. Has that been tried out somewhere else? If not, it seems logical to have a prototype and see if that prototype works before you spend all this county money doing it, because if the prototype doesn't work, you're saving the county a lot of money. I'm also interested in perk testing, and specifically up in the Bellevue, the land off Bellevue. Nobody can tell me who did that perk testing. It was done finally, which I would have thought the planning board would have asked for earlier, but it was done in early December. Don't know who did it. Would like to know the results of that. So I do have questions about berming, and I think it's great you're adopting the latest stuff, but in that design, we're talking about specifically outfall and berming. I'd like to know about. Thank you.
Thank you. Joy, you want
if
to
I
clear
could,
some of those things up for us?
try to clear it up a little bit.
All right.
This is not a specific design. This is an ordinance change to require new designs to meet a stricter standard. It is, we will require perk tests. We do that for all new ponds that are being built. Some do have berms installed, or where they build up the back slope where it didn't have one before, so they're not just digging a hole. They do have to berm sometimes the back slopes. When they do, they have to meet certain compaction tests for those to make sure they don't blow out. Again, there are some that don't have a positive outfall, so they do have to do on-site 100-year retention. What this does is increases that amount of that ordinance. This ordinance change will basically increase that amount. I believe, what was the percentage? About 22 to 25% increase in the size of a pond if they don't have an outfall. So hopefully, and we'll see a greater amount of freeboard in there above that discharge elevation. So we should see this stricter standard and make some improvements for future developments. And I've lost my notes of what your last question was. Oh, that was it. The perk test is required for all of those. So it's not exactly, this is not proposing a particular design. It is proposing a stricter standard for designs in the future, for any of the designs coming in for subdivisions and that sort of thing.
Okay, so the berm.
Just get you at the mic so that the public can hear it if they're listening in. Sorry. Or I'll ask it for you if you want to sit there.
Might be easier.
Sorry.
Oh, I can't even see that. I don't have my glasses.
Chris,
What does that mean?
Chris,
Oh,
if you don't
okay.
mind, Chris, can we let her speak?
Well, thank you, Chris. So the berm is to, in my mind, a berm is something that, like, if I have something here and I put a berm, it's
Contains it, yes, ma'am.
Okay. So, how does the water get in if you've got a berm? The berm's blocking water from flowing into it.
It would block the water from flowing in or flowing out, you're right, but there would be other devices or structures to take the input from the streets and the surrounding area.
All right, so.
Like inlets and pipes and that kind of thing.
Okay, so there is no design like it
Yes, ma'am.
in this area?
Yes, ma'am, it's not new.
That's a pretty
to- it's-
typical design, actually.
I'm sorry. Pardon me, sir.
Okay. But are they working? I mean, there's so much flooding especially in the Bellevue area. Some of the ponds have outfalls, some don't. They all flood anyway. So that's my concern. I would love to see a design, a prototype somewhere. But I know that's, you've got different soil types and densities. So it's just, I do commend that you're upgrading to current rainfall data and standards, but I'm just worried about berms. I mean, just to let you know, at Hogan Pit, when it rains, all the water goes to my yard, not to the pit, which is right behind me.
So, all right, thank you. All right, Andrew Bluer, we got you up next. Just state your name and address, and we'll get you going.
Andrew Bluer, 6101 Midas Place. My question is, does engineering even know what a transit's used for? I mean, is it just a more stable place to where you can prop up against than a shovel? I mean, you see people propping up on a shovel, whatever. Do they think a transit is just something that's more stable for them to prop up on? Because engineering has spent over $6 million on Hogan's Pit to collect water to dump on me. But yet, I'm not a subject matter expert, but I've lived it for like 32 years now of that Hogan's Pit, which they go home to their, I mean, just, what was it, the county administrator or whatever we had before? He says, I live on top of a hill. I don't care where the water goes. And that's just like Godwin Lane over there. They've done 3 stormwater projects on Godwin Lane. Well, guess what? Godwin Lane's on top of a hill. They've done three stormwater projects on that, and they still got water coming toward me that'll flood my house. I can't figure it out. So they were saying they don't know what a transit's used for. They got Zachary Estates and Suffolk Field Pond or whatever. I'm gonna break it down there very simple to you. I've done this to the 5 county commissioners. Well, over 5 county commissioners, because now we got 3 new ones. You got a 5-gallon bucket. You drill a hole, a 2-inch hole in the side of that 5-gallon bucket. How much water will that 5-gallon bucket hold? Half as much. But yet we got county engineers on Zachary Estates and the Sofley Field Pond put a hole in the berm. So you got an emergency spillway, but that emergency spillway doesn't work because the water is leaking out.
Mr. Bluer, can we stick to the ordinance, please? If nobody else is going to do a point of order, I'm going to ask for it.
Well, I mean, the point of order is if you have regulations, you have a designed pond, but then you go and breach the design of the pond. What have you done? What are we doing here with this irregulations and laws or whatever y'all doing? what are you doing if the county will come in there and breach the berm and it holds half the water that it was supposed to have? That's why Perkins Street's flooded. And they say, oh my goodness, Perkins Street's flooded. We're gonna have to do something about that. But it was because they went in there and drilled a hole in it. The house behind the softly filled pond.
Can we
That
please-
house flooded.
Can we
I'm not
please-
sure what, I don't know about that issue, to be fair,
I'm
but.
trying to get somebody in engineering to look at it.
I gotcha.
We had a
Yeah.
talk with Joy Blackman
Yes,
and Wes Marino and the county administrator at that time
Understand.
about 4 years ago. So have
Understood,
them
but
answer that
thank you.
question.
All right, we have Chris Kerr, we got you up, name and address, and we'll get your time started.
No answer for that one.
Mr. Brewer, we're here to discuss the ordinance. If you have any questions, I welcome those about the ordinance.
We're not gonna have a back and forth right now with staff or anybody from the public, so Mr. Kerr, if you'll go ahead.
I have a couple of handouts here, if I could submit them to the board.
Yeah. You good with that? All
You
right,
can ask him to either summarize the points that he has written, or you could consider accepting it into the evidentiary record. However, past practice has been to discourage written reports submitted as evidence. But it is
This
at
is
the
an ordinance,
discretion of.
dude.
Oh, I'm
Yeah,
sorry.
this is a-
I misspoke. You can consider it, and it's at the discretion to enter it into evidence.
yeah.
Sure. First of all, it's a summary of what I'm going to speak on, and second, of it's a DOT source of information.
All right. Do we need to vote to accept that, or we just? We got one more, he's out on the phone. There's 6 of us up here.
Okay. I think I got 6, 7
Okay.
copies here. So
We can share if we need to.
And you can take a look before accepting it into
Okay.
the evidentiary record.
Thanks.
While it's dead time, can I ask the lawyer there, do I need to sue the county to get an answer to my question?
Mr. Brewer, we're in the middle of a meeting and we got an agenda item here in front of us, so we're gonna have to take this first, and I don't know if this is the forum to ask a question. So,
They can't give you that advice anyways.
Mr. Chair, can we have our
Yes, sir.
speaker explain? We'll
yeah.
look at-
Give
So
us a
you
couple-
ready for my testimony? Or do you want to?
You want an explanation of this before he starts his
He said
testimony?
it
or-
was- is basically a synopsis of this.
I
I'd
gotcha.
like to hear him speak, and then we can decide whether this
Okay.
needs to be, introduced or not.
sound good with?
You guys
the rest?
wanna take
Okay.
more time?
Great, thanks.
I don't have a digital copy, so I'll email it to you, Andrew. So you ready?
Yes, sir.
Okay. I'm Chris Kerr, 5999 Somerset Drive, Flood Defenders. Section 1-1.2, using adopted FDOT rainfall data, which is basically NOAA Atlas 14, and in 2026 will be NOAA Atlas 15. This is good, and I'll tell you in a minute why it's good, but I'm all for this. But there is a little problem here with the ordinance where it talks about a minimum freeboard of 0.5 feet or 6 inches for a 100-year 24-hour storm in a closed basin. A pond in a closed basin has no positive outfall that only meets a 100-year 24-hour storm with a 6-inch freeboard is a flooding liability to the properties around that pond. Where did the arbitrary and capricious 6-inch freeboard originate? Because it's not based off of science. I know where it originated, but I'll tell you that later. I spoke at the Professional Advisory Committee when this ordinance was proposed, and I did not agree with closed basin specifications. I presented what DOT requires for closed basins, being a 100-year, 7-day, and 10-day storm event, thus the handout. This should be added to the language of this code. When the county engineer debated that she would be, making sure ponds designed in vulnerable areas and take extra measures to ensure that, they're not going to have any flooding, well, that's good. I commend her for that. But still, this is inconsistency in application of law. You can't require somebody to do something in one area, something in another area, do something different. The rules should be clear for all. Special attention to certain flood problem areas can easily be achieved by the county engineer, but the problem is the 6-inch freeboard for closed basins is arbitrary and capricious, not based upon science, and such will open the county up to problems like the Velma, Muldoon, Softly Field, Hogan Pit, Pond, Bellevue project. By the way, what's the cost estimate for that project? I think it's around $20 to $30 million to provide outfalls for county ponds that don't have outfalls. Philip Walker, who sits right here at that PAC meeting, he agreed with me. And when I said the county should be adopting a 100-year, 7-day, 10-day, 10-hour storm event for closed basins. However, the PAC approved it anyway. Is that my time, or can I finish?
You can wrap it up.
I'll wrap it up. In 2022, Florida statutes were revised to require DOT to submit a resilience action plan, included using the most updated NOAA precipitation data. In June of 2023, they submitted a resiliency action plan. Thus why NOAA Atlas 14 was adopted and DOT got rid of their 1979 archived rainfall data and marked it not for use in design. But this also required a little pushing from Flood Defenders with Ms. Green, the DOT state drainage engineer. There are some other considerations. Congress, through the American Flood Coalition, pushing them, they passed the Precip Act and the Floods Act. What that does is that requires that NOAA update their rainfall data every 10 years. In 2026, we will have NOAA Atlas 15. The Floods Act establishes an interagency committee on water management and infrastructure to ensure federal agencies work together on water-related issues. So what does that actually mean? Well, it actually means that in 2026, we're going to get NOAA Atlas 15, but all these grants that we get from the federal government, You're going to have strings attached to them like the Clean Water Act and the National Environmental Policy Act. Local municipalities will have to meet the design standard strings attached to those grants, like using NOAA Atlas rainfall data, and eventually we're going to have a national stormwater management standard if the American Flood Coalition sees it that way. So I request that you change this language right here. Where is it? Scratch the minimum freeboard of 5.5 inches and change the 24-hour to a 7-day and a 10-day storm for a 100-year frequency. You can do that right here at this board meeting, and I'll be a happy camper.
All right. Thank you, Mr. Kerb. So I know we want to decide if we're going to let this into, I guess, the record essentially after hearing the comments from Mr. Kerb.
Well, that's fine. Mr. Speaker, I'd like to hear our engineers, their response to that, and, as far as validation or verification or where the information that came up out of the blue theoretically, I'd like to get their response before we vote on this.
Okay.
Just briefly, it's not out of the blue. As I said, we had several PAC meetings, and it was discussed at length, and I respectfully we've chosen the half-foot retention freeboard. It's, if you want to call it arbitrary, I can respect that response. The science he's speaking to is also a decision that's made based on empirical or what have you. So I'll let Philip speak to that part of the conversation so that you can hear the background on that.
Sure. Thank you, Joy. So I will say that, a part of our process of looking at the NOAA 14 and providing recommendations, currently there's no freeboard requirement on a closed basin stormwater pond. So our recommendation to the planning board was, consider adding a freeboard criteria to the DSM. And that is what we're here today discussing having been adopted. Furthermore, I would say that for the closed basin stormwater ponds, FDOT does require the 3, the 7, and 10-day durations. That's because these ponds don't have an outfall. And so, Hurricane Sally was a perfect example storm for us. It rained for 3 days before the storm even got to us, and then we had the most intense, it was essentially a 100-year 24-hour storm after we had just had a 100-year 72-hour storm. So that is why FDOT does require that those closed basin ponds are run out for longer durations, because they want to know what the impact of, over a week, how much does the pond recover, draw down by percolation, and then how much does it fill back up? And so it's more of a service life of the pond for a closed basin analysis. And that's just what I wanted to add there.
And I'd ask the engineers, the information, I don't know if you have copies of this as well. I mean, do you disagree with any other than the fact that, I would say that, federal grants are going to be tied to whatever the federal grant's from anyway. I mean, I don't know of any money that people are giving away without strings attached to it to some form or fashion. But I guess to his point, would you agree with the validity of this information that's given to us, and as far as the table is concerned? And I mean, look, sounds like we're making a step forward. We're making progress. That's a good thing. But
Your recommendation can be different from what the PAC's recommendation was. It's perfectly fine. I just provide the data for the conversation. I have to try to work between the rock and the hard place to determine what's the best balance. While there is no positive outfall in most cases, in our scenarios, they are smaller closed basin issues where I hopefully will be able to find an eventual outfall for them. They're just not a direct positive outfall. And the DOT's impact, if those ponds were to overflow, are significantly higher than what ours would be. However, that doesn't mean it's not important. It is what it is. But if DOT ponds fail, interstates and other significant infrastructure could be in failure as well. So it's a balance. I'm not saying it's wrong. I'm saying it's more stringent. It may be what the board wants to go to. I'm here to support whatever guidance they have in that regard. Again, they are different methodologies.
You know, I'll add the freeboard criteria is over and above. I mean, that's what we're talking about right now. So the ponds are still being designed, 100-year event. You know, we're talking about using the new rainfall data and everything. So any amount of freeboard is a good thing. It's over and above. So just something to keep in mind.
So, I mean, taking this into consideration, would it be that, I forget how often the professional advisory meeting or committee meets. Could we send this back with taking this consideration? I hate to defer something, but I mean, maybe just to take it under consideration one more time, just to say we vetted it?
I don't know that, I don't have a committee meeting lined up anytime soon. I'm also running without a deputy director, a stormwater division manager, or a stormwater reviewer for the DRC, so I'm it. So I don't really have the resources right now.
Okay.
I would ask if you would consider it. That's perfectly fine. If you'd like to send it forward to the board with this in consideration, our PAC, as well as you are aware from past discussions at the board meetings, both sides of the equation will be there to discuss it with the BCC. So I think it's perfectly fine if you want to amend or suggest that it be considered. I certainly wouldn't have any problem with that. I'm sorry.
Chris, and I just want to get some clarification for the guy that sells lumber and tries to keep downtown clean. You said to include the 7 to 10-day, 100-year frequency?
It's where it says 24-hour, change that to 7-day and 10-day. And then you can scratch the 6-inch freeboard or the 5.5 foot. This is 6 inches.
I got you.
Okay?
So,
and it's spread over a whole pond, so it is a volume amount.
I got you.
But this is 6 inches.
Yep.
That's arbitrary and capricious. That information came from a recommendation in Santa Rosa County.
Let me keep moving. Joy, what does that do with that change in your mind that you don't agree with? Or maybe not don't agree with, but didn't think was necessary for this ordinance change?
I think it's just on a scale basis. I feel like the freeboard requirement does, with the added volume that we're already asking for on the NOAA Atlas 14 and any future updates to that as it comes along, as well as the 6-inch freeboard over that entire area of pond on a scale for what we're dealing with in subdivisions is typically pretty significant in terms of volume. And it's not that I don't understand the idea that DOT is looking at is a cyclical type thing. In other words, and Philip spoke to that, is the recovery time of a pond is important. But we're also looking at recovery times as well. So if we see the pond's not recovering like it should, then, you know, we can, or we see the perk rates are not good, then we can make some adjustments to that. But to Chris's point, I mean, this is a methodology. It was discussed at the PAC, and those professionals decided that this was adequate and the proper way to go. So I'm just bringing that forward as well. So that's their recommendation. But, you know, all of these things are subject to the BCC's approval. So if you would like them to know that you've taken that into consideration and you have concerns with that, I'm happy to represent that as well for you.
Okay.
Yeah, let the BBC have an option.
I'm with you. So this is for, again, as we stated earlier, any new storm water pond going in, whether that's by the county or by a private developer, correct?
It's for new developments specifically.
New development specifically?
Yes, sir.
All right. and you might not have the answer to this, but what is, in developing a stormwater pond like this, and you're not going to be able to answer this, but I'm going to ask you anyways, what's the cost difference in what you got here and what is being suggested by Mr. Kerb?
You're probably going to have a better answer than I am on that because you know more about real estate than I do. But you're going to see a reduction in the number of lots that can be developed in a subdivision. That's the short answer. It's going to also impact I'm going to say the number of parking spaces or something to that effect relative to an apartment complex, which is usually a big issue as
So
well.
what we see in
Those are the things that have to be taken in, that impact the cost. That's really all I would
we
give
see
you on that.
use up usable acreage typically in commercial, but I mean, we've been using more turtleback designs and on-site retention and detention, so I mean, a lot of this is factored in. I mean, it's more advantageous for us not to have it, but I mean, I get it fully too, so.
Understood. I think I got everything I needed, unless you want to add anything else.
I would like to add something. $36 billion. That's our national deficit with the National Flood Insurance Program. $36 billion. That's in 2023. That doesn't include 2024. We are not handling stormwater in this country, in this state, in this county like we should be. Why don't the county step up and modernize like Ashley ran on? Let's get modernized. Let's go with science. Let's not go with arbitrary and capricious 6-inch freeboard. That came from Santa Rosa County. They're 30 years behind us.
I gotcha.
Thank you.
Thank you. All right, board. So we've, I don't know if anybody else has got questions or anything, Mr. Blue, or if we make it quick. And
That's what I want. 6-inch freeboard. What are y'all saying on that? So when the water comes up above that, it's going to overbank, and I mean that's going to be like.
As opposed to zero currently.
Yeah, opposed to zero. What's the difference? I mean that means you're going to get 6 more inches of water breaking through a berm, I guess.
No.
You're going to, huh? What when it tops that? When it tops the 6 inches, when it tops the 6 inches, it's going to go over the berm, right? And it goes over the berm. What's it going to do? It's going to wash out the berm, right? So you got 6 more inches of water over what was the capacity of the pond, right?
Yes.
So why don't you have a hardened we or something other in there? If you're going to adopt the stupid thing, then you ought to at least have a hardened we.
Gotcha. All right, board.
They don't even know what I talked about.
If we'd like to figure out how to proceed, you can say it from there, and I'll repeat it so we got it on the record. What you got?
Okay, I'll try to talk loud.
Yes, ma'am.
It is the free board that also concerns me, because if it overflows, there's no place for it, there's no way it's gonna go back into the pond. It's gonna flow out to all of us that surround that pond. So that's why I'm so concerned with that. And how does that pond collect the water anyway? I would hope that the pond is low enough that when it's raining and raining and raining and water's building up in my yard, that it will flow down to Hogan's Pit. And it won't be able to get into the pit if there's a free board. And then if the pit overflows, then it's gonna come back twice in my yard, because the first water couldn't get out, and then the freeboard water won't be able to get out. So that is a concern with the freeboard for me.
Thank you very much. So,
I just wanted to clarify for the record, requiring freeboard is requiring additional pond volume that is not anticipated to ever be used. So what you would do is you would figure out what your maximum stage of your pond is for whatever design storm event, whether it's the 100-year, 24-hour, 72, any of them, right? And say that that top elevation of water is elevation 100. What we would say is the minimum that the berm can be is elevation 100.50. And what that does is provides a factor of safety in the pond design so that the pond can retain more stormwater than the maximum of the theoretical models that were ran during design.
You can't dig it deeper to achieve the same thing?
That gets into more variables.
Well, yeah, you dig it deeper and then you're changing policy. Right now, the policy is a 100-year, 24-hour design. So, you know, you could dig it deeper and make it a 200-year pond, but that's not what current policy is. We're talking about over and above current policy.
Okay. Board, is there any further questions for staff at this time? Any direction on how you would like to proceed with the evidence that was presented by Mr. Kerb and that we've got in front of us, or his testimony essentially written down?
No, Mr. Speaker, I just want to say thank you to Joy, Ms. Blackman, for presenting this information a step forward. I want to, earlier we had mentioned something about impervious parking, and our county facility here is a great example of pervious parking that's supposed to be a model for developments coming forward. While it's easy to throw rocks at the folks who are taking the responsibility and trying to fix things, Mr. Bluer, you may need to apply for the position that Ms. Blackman has open, available to help out. But I think this is a step forward. And I say we should, I don't think we need to admit this information. I think he was very articulate in explaining it. And if they're going to be present at the Board of County Commissioners, they can also present that information as well. But I think it is a step forward. And I'll leave it up to the board if you guys want to add that additional language or not.
Are we going to be notified of the BCC meeting on this? I checked a little box on that pink piece of paper saying I'd like further.
February 4th, 8:30.
No, the BCC meeting for this item is Wednesday, January 22nd at 9:15 in the morning at the BCC chambers.
All right. So
That's just letting you know when the next planning board meeting
we
is.
got something you want to add?
Wednesday, January 22nd at 9:15 a.m.
Okay, Mr. Chair, I'm asking for clarity here are we looking for a motion? And if that motion is to include any change to the written draft, does that have to be articulated in the motion?
We need, if you wanted to change, make an amendment to the draft itself, we would have to have a motion on that amendment, vote on that, and then vote on the, what would then be amended version of this ordinance in front of us to move forward. Does that make sense?
Understood.
So I'll take any kind of motion we got on the table. Right now, we don't got one.
I'll make a motion to move, excuse me, to move forward with, as advised by staff with the current language. And I'd like to add this as additional evidence for the BOCC if they want to send it back to staff for a revision. That's entirely up to them, but the motion would be to move forward with this added as, excuse me, as additional evidence. And
Yeah, I will second that fully.
Okay.
Yeah, I will take that, yeah, that's fine.
Great. So we've got a motion to send on what we've got in front of us, plus adding this testimony here with it that provides an alternative option as well for them to consider. And so if there's no further discussion on that motion, all those in favor of the motion, please signify by raising your right hand. All those opposed? All right. Thank you very much. And then that'll be on the next Board of County Commission meeting. And then any action or discussion items?
I had a quick question. So you accepted this ordinance and that document that I submitted?
Correct.
To be presented for consideration.
Yes, sir.
Option A.
That's right. So any action or discussion items or info from staff? All right, we didn't have anyone sign up for public forum, nothing from the county attorney.
Tim,
And then
thank you
we've
for your
got,
recommendation or whatever. I want to be Doge of
Thank you.
Escambia
And then-
County. I'll have to come up with new. I might
Thank
be as
you,
crazy
Andrew.
as
Hold
Elon
on.
Musk or whatever.
all
But
right,
if
we've
you'll
got
give
our
me access
Andrew,
to engineering, I
Mr. Bluer,
appreciate it.
Mr. Bluer. Our next meeting is Tuesday, February 4th, so we'll see you all then. Do we have some cases scheduled?
I have a rezoning and opt-out.
Okay, great. All right, thanks so much. We're adjourned.
Thank you.
Horace, can I have a minute with you and Joy?